SJC-11360, Commonwealth versus Sanchez.
Good morning, Your Honor.
Good morning, Ms. Berinsky. Just give us 1 second. Okay, we're all yours.
May it please the court, my name is Elaine Perinsky, and I represent the appellant in this case, Mr. Benjamin Sanchez. The victim in the case was the estranged wife of Mr. Sanchez. This is a case that involved a fairly horrific murder where the victim was stabbed approximately 18 times, and a number of those wounds were defensive wounds, which would indicate some sort of struggle. She also died of
18 stabbing wounds? I thought there were 45 stabbing wounds.
my recollection, if it's 45, I'm sorry, my recollection was that it was 18, so if it's 45, then that would even make it even more horrific. And she also died from the inhalation of soot and smoke because there was a fire. This occurred at approximately...
There were also blunt trauma wounds, were there not?
Yes, there were
And
also...
choking,
I'm sorry,
indications of
neglected
choking?
yes, there was a significant number of bruises and the like. So there was a substantial struggle here and a fairly messy crime scene. This occurred at approximately midnight. A short 3 hours later, the police went to Mr. Sanchez's home, which was located in a trailer park in Better Way. There was no evidence whatsoever of the victim there. There was no trace blood. There was nothing. They searched his car, was tested for blood, the house, and he was. There was some wounds on his hands, but there was testimony that he was an individual who liked to punch the punching bag. There was a punching bag there. And Mr. Sanchez is an individual of significant deficits. He doesn't read or write. He has mental illness, as his lawyer put in the affidavit. He always hears voices. He has learning disabilities, and he had an on and off drug addiction for a period of 20 years, which
There was lack of criminal responsibility wasn't the defense,
no,
was it?
no. The key issue in this case is, which I'm leading up to, is the identification of the perpetrator. Because one would expect that, given the horrific crime scene, the shortness of the time in which they went to the defendant's home, that you would find something, some physical evidence. And that was not the case here. The Commonwealth case mainly presented a case of motive and perhaps some opportunity. But I think what I just, I'm sorry.
I'm sorry, but I'm just trying to get my facts straight. His car was seen going...
His car, well, what they believed was his car was seen at a certain time going in and out, which and I believe he told the police that he went a couple of times to go buy drugs. He was a heroin user. But I think the facts which I just stated and the lack of the physical evidence underlies all of the arguments which I have put forth in the brief. And the first one which I'll address is the substitute analyst. And I know this court has addressed that in Barbosa and Grenadier. But I think this case is distinct from that in that it was a very key piece of evidence.
Didn't the testifying analyst actually do it all again from the raw data, the raw testing? I thought she redid it, no?
Did she look at the raw data? And the raw data didn't go into evidence, right?
I don't believe that she did it all herself.
No, the analysis of it.
Yeah.
Right.
She did her own analysis and opined on the basis of her own analysis of the same raw data. But the raw data didn't go into evidence.
The raw data didn't go into evidence. She did her own analysis of the raw data. But in this particular case, when she testified regarding what are her duties, she testified that one of her duties, she's a technical reviewer, and she reviewed the raw data. And she testified that one of her duties is to make sure that the conclusions drawn, not the testing, the conclusions drawn are technically sound.
Isn't
So
that-
in a sense, she testified to the opinion of the analyst who did not testify.
Well, isn't that in conformance with Commonwealth versus Tassoni, where we have a analyst or a supervisor from the same lab who can be cross-examined as to protocols by the defense attorney because of their superior knowledge of that lab versus Cellmark or some other outside lab?
You know, I believe they can testify to, but not to conclusions. That goes to testing, not to conclusions drawn. So in a sense, she testified to the opinion of the analyst who did not testify.
Was he talking, or was she? I shouldn't say wasn't she, because I haven't read that. But was she talking about, this is what I do as the technical reviewer generally?
Right, she testified, she was a technical reviewer, she was not the direct unlike Barbosa, she was not the direct supervisor of this person. She did
But
not
as
oversee
it,
her
isn't it,
work.
this is what a
but as
technical reviewer does?
reviewer, she ensures that the conclusions are technically sound, which I think the Commonwealth, the prosecutor picked up on that. Later, when he said to her, well, I don't want you to talk about the conclusions drawn, but it was too late. That was already out of the bag. That her job was to make sure that the conclusions, and I think you need to make a big distinction between testing and conclusions, opinion and method. I think in this case that puts it over the Barbosa gate or the Barbosa wall or whatever you want to call it, and puts it into an area.
How is this different from a medical examiner who looks at a file, looks at all the photographs taken by the other medical examiner, didn't do the autopsy, but looks at all the photographs from the other medical examiner and looks at the other medical examiner's reports and then comes into court and says the person was stabbed to death based upon my review of the file, which was the photographs, et cetera. As long as the substitute medical examiner doesn't put in or testify to the conclusions of the first medical examiner, haven't we said that's fine?
I think if it happens in that way, then that's fine, but I think in here, they did put in the conclusions of the other medical, the analyst,
So what did she
by
testify?
stating that.
What did she testify to in response to that? I mean, did she say, I analyzed data and this is what I concluded?
She said that her job as a qualified analyst is to review, I don't have exactly what she said in the beginning, but in the end she said, and to ensure that the conclusions drawn are technically sound.
And she didn't
And-
independently opine?
She did that. So in a sense, we had two opinions in this case, one which was cross-examined and one which wasn't.
But I'm still trying to, I mean, she can say, this is what a technical analyst does. That's different from
This is
what
what
she did in this case. And
This is
which
what
one was
she
she
does.
talking about?
This is what she does, this is what she did in this case.
She said, I checked to make sure that the conclusions drawn by the analyst who isn't here are sound?
No, I mean, she testified, this is her job, to make sure the conclusions are technically sound. I reviewed this case, and in my opinion, this is what this is. I don't think it's a big jump for a juror or anybody to make, that it goes back to what she said in the beginning, that the conclusions are technically sound. So, in a sense, you got two opinions here, and one was not subject to confrontation.
But is she just saying basically in the first part of it that this is her job generally to make sure that the conclusions are technically sound, not that she did it in this case?
Well, she did review in this case. I mean, she didn't specifically say the words, but I mean, I think it's clear to the listener, the fact finder.
Isn't the touchstone the ability of your client to effectively cross-examine this technical evidence? And here, your client can challenge whether or not their thresholds were made, whether the squiggles were of all the fodder for cross-examination in a DNA case. That could be asked of this witness, correct?
That's correct. And I'm not saying that wasn't done here. That was done here. But also, you can ask about their opinions, whether their opinions are
But, so there was cross-examination as to the technical part of her,
Right, as to the testifying witness's opinion, not as to the other
Right.
witness's opinion, which I don't think it is.
and was there a
great-
DNA expert on the other side?
I'm sorry?
Was there a DNA expert on the other side?
There was a DNA expert on the other side.
Did the DNA expert testify?
No, I don't believe he did.
But as a consultant?
Yes. I could be wrong on that, but, so I would ask the court to consider that, you know, and like I say, it was picked up by the prosecutor, that we don't want you to testify as to the conclusions, because I
Now, I'm
think
sorry,
he was
did-
trying to go back and correct what she had said.
There was an objection to her testifying in this case?
There were numerous objections. This is an attorney who was not afraid to object.
Okay,
And there
but
were
was there an
numerous
objection to the specific, you identified specific testimony where
There-
you
there
suggest that that was the testimony that indicated that she was saying that the original examiner had actually found what I found. Was there any objection to that?
There was an objection to her whole testimony.
Right, but was there any objection to the one where you say, oh, that's the one which she specifically referenced the earlier examination?
To be honest with you, I can't say with a positive face.
I mean, because it's not, I mean, is this any different from the many, many cases we see in which the ADA says, tell me what the protocol is in your lab, and it says we don't, it's always reviewed by somebody else before we issue a report, and so when somebody testifies, the jury understands that two people had reviewed it and come to the same conclusion? I mean, that's pretty common in these types of cases.
But I think this is an issue that, where this was a very key piece of physical evidence, that you should look at it with high scrutiny here, because there was no other real physical evidence in this case to connect the gentleman to the crime scene. And the major donor was the victim herself. There were minor donors to the DNA, and
This is one part of the DNA, right? Because it was STRs and YSTRs.
YSTR, and then there was found something under the fingernails, but the YSTR would check the
My
paternal line, so it would also, the son also lived there.
Right, so the
So-
numbers are obviously way different.
Right, so but
the
this-
YSTRs, there were no problems such as this that you identify in the YSTR testing, right?
Right. So I think that's why this witness should be looked at. I mean, and you could see the frustration of the attorney in this case of not having the main witness, and a defense counsel should never be put in the position of putting on the Commonwealth's case by having to call the witness and do the direct examination and not the confrontation, the cross-examination. And I would suggest that it's linked to this argument, but not as important as this piece of evidence, but linked to this argument is the failure to call the actual electrician in the case. They called the substitute person who basically said he relied on the other person, the non-testifying witnesses,
Wasn't he giving his own
expertise.
opinion, though? Wasn't he just giving his own opinion as to the fact there was an arson?
He was giving
And
his,
used this as one of the underlying things that he relied upon?
he was giving his own opinion, but he basically said he wasn't qualified to give that opinion, that but for this other person, he would not have been able to do that. So again, I think it was frustrating for the defense attorney to have these other witnesses called in instead of the actual people who did.
But the electrician essentially said there was no electrical malfunction that caused the fire.
There was no electrical malfunction that they found, right?
But the likelihood that there was an electrical malfunction at the same time that she was stabbed and beaten doesn't seem very high.
No, it's not very high, and it's probably unlikely, but I added this and added the next person, because it appeared to be a pattern by the Commonwealth of not bringing in certain witnesses. And it's a very frustrating experience for defense counsel, and I think it thwarts the real purpose of the Sixth Amendment. You know, and then that would be during I spoke about during the motion to suppress, the failure to bring in the Officer Jones, and you'll see.
Ms. Lynch says, in fact, Officer Jones testified.
He testified during trial. He didn't testify during he was unavailable during the motion to suppress because of some eye issue. But apparently he was someone who was available. He was retired and he had an eye issue, but then he was made available for the trial. But the motion to suppress, I would suggest for counsel, defense counsel, is a very crucial part of the whole process. And it was a very, just jump into that argument of the motion to suppress. It was a very crucial part of why the defendant made the third statement. So I'll discuss that further in a couple of minutes, but if the court has no other questions on the whole DNA issue, the substitute analyst, I'll move on to the motions to suppress. In this case, the defendant made 3 statements. The first statement was when the police did knock on his door at 3 a.m. in the morning. He was sleeping. He was brought to the police station. His family members drove to the police station, but he was brought in the police car to the police station and held at the police station for a couple of hours. As I explained before, this is a defendant that has numerous deficits. And these were known to the police because they were told to the police. Despite that, and he was an individual who was on medication, but no question was asked about, have you taken your medication or anything like that. He could not read or write. The officer in the first statement admitted that some of the words were not the defendant's statement and he would not have been able to read them. And that he suffered from depression. And also, the court found in this first statement that when the police officers told him that the deceased was pregnant, that they did it really to destabilize him to even further, especially after he just found out that she had died.
Was that a lie, or, I mean, I get the part about destabilizing, but I'm just wondering, do we know whether that was true or false?
It was a lie.
It was a lie.
So those, I would suggest that the first statement that he should have been Mirandized because he wasn't, I would suggest that he was in custody. He was brought to the station even though he could have gone, should have gone with his family members.
Wasn't he let go?
He was let go, but he was there for 2 hours. I don't think he probably felt free to leave. And with his numerous deficits, I think it only adds to that feeling. The second statement, and I would suggest that the statement was involuntary given his number of deficits, given their failure to take any precautions to try to assess, did you take your medications, how are you feeling now, when's the last time you used heroin, anything like that. And he certainly was a suspect because there had been a restraining order. He was the estranged husband, so he was the obvious suspect. Because they always are in these cases.
Do we have videotapes of all 3 statements?
I'm not, I hope you do. If you don't, I can get them to you.
But I mean,
you had
they
said
all
that
were
the-
videotaped. All
2
3.
of them were videotaped.
2 out of the 3 were videotaped.
The first was not.
The first one was not, the one when he was not yet in custody, arguably.
Now, the defendant, Mr. Sanchez, was arrested on July 17th. And at that point, he said something to them to the effect of, I take too much medications to even know what I ate yesterday. So then they're on notice once again of the deficits of this man, and they are numerous. And at that point, he invoked his right to counsel. He gave the officer a counsel's card, and I think the court found that it was unclear whether the defendant realized that he had to be the one to call his attorney or whether he thought they were going to call the attorney, that the officer was going to call the attorney. And when he invoked his right, the officer made some comment to the fact that he was disappointed in him for doing that because he's not really protecting his young son, Angel, Angel. Benjamin and his wife, they had a child, Angel, and they both took care of they both had a loving relationship with the child and took care of the child. But I just want to point out, I see that my time has ended already, that this occurred on a Friday afternoon at 3 p.m., 3:16. He invoked his rights. The court was still opened. He was not taken directly to court after he invoked that vital right of wanting an attorney, and he was held over the weekend, and 18 hours later, he made the next statement. So I would suggest it's a clear violation of that.
Is there a Rosario issue here? I didn't see it mentioned.
I'm sorry, I did not mention that issue.
Okay, thank you. Ms. Lynch, good morning.
Good morning. May it please the court, Bethany Lynch, Assistant District Attorney for the Hampden District, representing the Commonwealth in this case. With the court's permission, I will address the arguments in the same order that my sister did. I'll start with the substitute DNA analyst question. In this case, I would suggest that this was the subject of a motion for a new trial, and the motion for new trial judge found that it was a proper substitution of the DNA analyst. The DNA analyst was Amy Barber.
Interrupt you. This is
Certainly.
not the trial judge who did the motion.
It was not the trial judge. The trial judge had retired, but the trial judge had made the initial determination that it was a proper substitution because Ms. Barber was only to testify as to her own opinions. None of Ms. Canassis, I'm not sure how to say, I'm going to call her the original analyst, none of her opinions actually came into evidence. And I think that is where my reading of the evidence differs from my sister, in that I see nowhere where analyst Barber referenced at all any of the conclusions or analysis made by the original testing analyst. The original analyst did run the first 2 or 3 steps in the DNA process. When Ms. Barber took over, she ran she reviewed all the data from the detection and analysis, analyzed it and interpreted it herself, and came to her own conclusions. She was also fully available for cross-examination as to all of the protocols of the labs, all of the different procedures that they utilized, all of the steps, all of which she was free to be cross-examined on.
Was she in fact cross-examined?
I don't honestly recall that she was cross-examined on those particular points. I think that the defendant used her instead to point to weaknesses in the DNA because this was not a strong DNA case. The strongest DNA that was developed in this case was the little bit of DNA that it was a mixture on a T-shirt that was found at the crime scene. The major profile belonged to the victim, and there were 2 minor profiles. One was unidentified, and the second did belong to the defendant with a 1 in 89,000 probability. So these were not the overwhelming numbers that we often see in cases like this. And it was a T-shirt in a house that he had lived in, and a house that he had admitted to have visited that day, or earlier in the day of the murder. So this wasn't wasn't a DNA case that was focused entirely on DNA to tie the defendant to the murder. And I would suggest that the motion judge and the trial judge were correct in finding that this was very much a Greinader case or a Barbosa type of a situation where the underlying data was never admitted. The only evidence that was admitted was the independent opinion arrived at by Ms. Barber, the substitute analyst, based on her personal analysis of the raw data, as it were. So in that situation, I would suggest that there was no error by the motion judge or the trial judge in allowing a substitution for a DNA analyst in this case, where the original analyst had left the employ of the Commonwealth, and I believe she was no longer in the state. And again, as the Tassoni case, this wasn't a case where it was an outside outside employee coming in. This was an employee, a direct supervisor at the lab who was fully versed in all of the protocols and procedures for the lab. So she was fully available for cross-examination, which is what the core of this confrontation right is in this case. Segueing into the issue with the electrician, the electrician was present at the scene with the arson investigator. This arson investigator, Trooper Percy, had over 20 years of experience in arson investigation. And while he had an electrician there with him, the electrician's opinion was not entered into evidence. It was something that he considered, but he was also there personally, and he personally observed that the outlets and the light switches and the electrical things in the room were undamaged. And the arson investigator observed these things as well. So he looked at not just the electrician told me that there was no electrical problem, therefore it was a set fire. That wasn't his opinion. His opinion was based on any number of factors, including the fact that there was no damage to the electrical outlets or switches, but also there were burn pattern issues. There was the fact that I think 5 out of 6 smoke detectors in the house had been removed or disabled, and all of them in the area where the fire was. There was an absence of an accelerant, which was discussed as well. He explained that sometimes that burns off. The bed had been burned completely, and the fact that it was a sort of a centralized fire, it was in this back bedroom and hallway area exactly where the victim was. He put all of these things together, and the fact that there was a victim who had been relatively recently killed in the area as well, and he put all of those things together in opining that this was a deliberately set fire, not an accidental fire. So the opinion of the electrician personally did not come in, and he, again, as the substitute DNA analyst, was fully available. The arson investigator was fully available for cross-examination, and he was cross-examined on the start of the fire, because the start of the fire was an issue in this case. So in that situation, again, the defendant's confrontation clause rights were not violated by the Commonwealth putting on a witness who observed the examination by the electrician and who was able to opine based on his own training and experience and on a great deal of data to offer an opinion as to cause of the fire. Moving on to the issue of the, of the motion to suppress. This is, I would suggest, the most complex of the issues in this case, just because there are numerous motions for motions to suppress. Oh, I'm sorry, if I can just return to a question that was asked about the officer and when he testified. Officer Jones, he testified at the motion to suppress. He testified on January 18th, 2012, and the trial in this case was at the end of February in 2012, I believe. So he testified at the motion to suppress, and I do not believe the issues about the invocation of the right to counsel or his reinitiation were part of the trial evidence. The second statement, starting with the July 12th statement. That's the statement the night of the murder. The defendant was not in custody at that time, so Miranda warnings were not required because this was not a custodial interrogation. He was, the police went to his house. They had just discovered the victim. She had just been declared dead. I do acknowledge that he was clearly a person that they wanted to talk to. They knew there was a restraining order, and they knew that there was an estrangement. But beyond that, they didn't know anything else about her movements, about his movements, about anything of that nature. So they went to his house, to this trailer, and knocked on the door and asked if he would be willing to come with them. And he said he would be. He was very cooperative. He got dressed. They drove him to the police station. He, at that time, had no trouble with English. All of these things were found by the motion judge and credited. And the July 12th statement is unrecorded, and it was unrecorded because he was not in custody at that time. The other statements are recorded, so Your Honors have, if you don't have copies, they're in evidence at the trial, or at the motion to suppress, I should say.
Are any of the statements inculpatory?
None. No, they're inconsistent. Is the most inconsistent.
And the Commonwealth commented on that in closing.
Absolutely, yes. No, they're not, he makes no admissions. What he admits to is that in his initial statement on July 12th, he denies all knowledge. He denies all knowledge. He says he hasn't seen her. He hasn't been to her house. It's entirely exculpatory, the original statement when he was not in custody. He's arrested 5 days later, and at that point, he gives a statement on the 17th, which again, it just reiterates the same denials. In his third statement, the final statement, after he reinitiated contact with the police, he acknowledges that he was there at the house that day, earlier in the day, helping to clean, and they had a sandwich together or something to that nature. And so that is the only, the main contradiction, is that he acknowledges that he was at the house that day, but beyond that, he makes no further inculpatory statements. He blames a third party.
Returning the dog, or is that?
I'm sorry.
He returned the dog, or was that?
I believe the returning of the dog evidence is in that second statement, the July 17th, right before, he says that right before he invokes his right to counsel. I do not believe that statement went into evidence at the trial. The July 17th statement was only approximately 10 minutes long. I don't believe it went into evidence at the trial. The July 18th statement did, but the evidence about the dog came in through his son, who
Now, at the
testified.
end of the 17th,
Mm-hmm.
there was a comment made after he
There
invoked his
was.
right to counsel that should probably not have been made.
It absolutely should not have been made.
Which
but-
was to the effect that he hoped Sanchez would make a statement to take Angel out of this. He was, but nothing,
Nothing came of that, Your Honor.
not
The-
that day, but I mean, is there
Not
any
that day,
question
and-
about whether or not that may have provoked?
The
to seek-
motion judge did not find that. The motion judge
Now,
found
this
that
is
it was.
videotaped, though.
It is videotaped.
Okay.
The defendant he reacted in no way. He made no comments. He was not overcome by this statement and began to speak to the police right again. He reacted in no way to the statement when it was made. 18 hours later, he does, at that point, reinitiate contact. He reaches out to this Officer Jones and says, I want to talk to the detectives.
What do you say to the argument that if it was 3:30 on Friday afternoon, that he could have been brought to the courthouse, had a lawyer appointed, et cetera, et cetera?
I
In
am in a difficult position, only because the issue wasn't raised in the motion to suppress, and it wasn't directly addressed by the trial judge. So I don't actually have an explanation as to why that didn't happen. I know I believe it was 3:17 or 3:16 when he invoked, so I would be merely speculating as to why they did not bring him to the police station right away. I do know that he signed a waiver of his right to prompt arraignment.
Oh, he did.
He
So
did
there's-
sign
takes
that.
care of the
He did
Rosario
sign
issue.
that at the beginning of that July 17th,
at the beginning of July 17th or 18th?
the 17th, I believe,
Oh.
before he invoked his right to counsel. No? Does
Well,
that
no,
sound
I
wrong?
mean, I have
No,
no
no,
idea. It's just, it
no,
seems weird to me, but that's.
I think that was part of the original, I'm sorry, I'm going to have to defer to the video on that. I may have that incorrect, but I believe that when he was brought into, on the 17th, which is when he was arrested, he was brought to the police station on the 17th.
And
He
so it was
speaking-
probably a form?
Right,
that-
it was
yeah.
part of the initial, when he was Mirandized and he signed his Miranda forms, and I believe he signed a waiver of prompt arraignment form then. He was interviewed for maybe, I believe the record indicates about 10 minutes, and that's when he hands the card about his attorney, and by then it's, quarter after 20 after 3. So that's really the only evidence that I can point to say why there may have been a delay. But again, because it wasn't raised below, I don't have, we didn't have the opportunity to have the police officers explain on the stand or anything like that, so I apologize, but I just don't have that in the record to be able to address with you. The issue about the July 18th statement, just to touch on very briefly, is I believe that the evidence is sufficient to show that he did reinitiate contact. The motion judge credited that. That is part that does need the trial judge, the motion judge's crediting of Officer Jones's testimony, where he said, I was just walking through, I didn't say anything to him, he just reached out to me and said, hey, I want to talk to the detectives, and I just called the detectives. From that point on, once he is brought up to the Detective Bureau, we're back on videotape. So, and he does address the fact that he does want to speak to the police officers, that they clear that up on the video. And again, those videos are available for your review. I didn't include them in my brief, but you can either get them out of evidence or we can provide copies of those for you.
I think if you could provide the copies, that would be a good thing.
Sure, we will do that.
I mean, or at least one.
Now, something was played to the jury, right?
Yes, the
One?
July 18th.
The last
The
one.
final one, yes. The final one. The interview where he invoked his right to counsel was not played for the jury. And I do not believe it was referenced at the trial.
Okay.
They did discuss, and I believe they read in the July 12th statement in its entirety. That was just read into the record because it was unrecorded. And then the July 18th was read to the jury. I'm sorry, was played for the
Because he
jury.
gave a written statement on the 12th?
He did, yes.
That's the one that was read into the
That was read into the
record. yeah.
It was
Into the record.
admissible, although it's a denial, it was admissible because it was in conflict with the 18th statement?
That was the theory, yes. Yes, that it was showing. And he does give some other background information as well. So, just about their relationship and things like that. Nothing that he hasn't put himself at the scene or anything like that, but there is some background information. So that information all did go to the jury, and I would suggest to the court that the motions to suppress on all three were properly denied. Finally, I will just touch on, there is a motion for required finding issue raised in this case as well, as it kind of ties into the 33E. And I would suggest that in light of the facts of this case, there was incredibly strong evidence that the defendant was the perpetrator of this crime. While there isn't a great deal of direct evidence, there is incredibly overwhelming amount of circumstantial evidence, I would suggest. The defendant, there was a restraining order against the defendant. He had a strong motive. He had threatened to kill her in the past if he ever found out that she was dating another man, and she was dating another man.
But those statements were pretty dated.
Yes, I'm sorry, they
They were-
predated the murder?
The victim's
dated.
wife, I'm sorry, the victim's children by another relationship were
Yes.
the ones who testified as to those statements, right?
That is correct.
And
Yes.
those statements were made before they had separated.
Yes, they
So
did.
I'm just saying that they were old.
They
If
were older,
threats,
yes.
They were old threats.
Yes, they were older threats, but the defendant was clearly still interested in whether she was dating someone. There was 2 days before the murder, there was a meeting between the defendant, the victim, and I believe at least one of her children, where he's asking her who she's dating, and he's very angry with her over custody issues and things. So I would suggest that this is still an ongoing angry or sore spot for this defendant. And he had also attempted to reconcile with her, and she rebuffed that completely. And he was very angry when he left that meeting on that day, and that was 2 days before the murder.
Did he receive any confirmation that she was in fact dating?
That's unclear. From the record, I don't have any evidence that I can point to. He clearly suspected it. He was asking the questions. He asked his daughter, but his daughter denies having told him. And he asked his son as well, and his son also denied that he told.
To be Angel, their son?
Their son said that he had never told his father that the son knew that the mother was dating
Yeah, because
this
he was
new
living
man.
with her.
Because he was living with her, but he had never met the new boyfriend, and he testified that he did not tell his father about that. He was seen on video, inferentially, but in his statement, he actually acknowledged that if you see my car, that's me driving it, I'm going in and out. There was another car that was similar in the trailer park where they lived, but the woman who owned that car was completely unrelated and said that she hadn't gone out that night. So in the light most favorable to the Commonwealth, that was the defendant coming and going, and he does acknowledge later, at least that he was coming and going, claiming to go get heroin. But the doors to this house were all locked. There were pristine keys found, and the keys included keys that only the victim and then the victim's son, Angel, would have. Angel was purportedly the only one who had a key to a basement room, and the keys, including a key to that basement room, were found on the scene, and they were pristine. The defendant at some point said that he had keys.
I'm not getting.
I think the inference is that he copied his son's keys because his son spends weekends with him.
I see.
So there were new keys that only the son had those two particular keys.
And the inference being the keys he said he threw earlier would not have been pristine.
Right, they would not, he said he threw his keys to the house into the yard months ago when he was asked to leave the family home. And his statements to the police varied. He couldn't be excluded by YSTR. What weak as that is in terms of evidence, YSTR did place, he could not be excluded from the YSTR test DNA under her fingernails. His DNA was found on a T-shirt with hers. And so all of this information, I would suggest, is enough to infer that the defendant is the perpetrator of the crime. The crime was a deliberate and premeditated murder, I would suggest. There were multiple weapons used. I believe there were 45, or I count 45 total wounds, 37 puncture wounds and approximately 8 either blunt force or ligature wounds. So there were many, many types of wounds. The victim, it was an overkill situation. He was also convicted of extreme atrocity and cruelty under that theory. The victim was aware of being attacked. There were defensive wounds. The victim, well, there's no evidence as to whether or not she was awake. The defendant did leave, or conscious. The defendant did leave her there and set the house on fire around her, and she did inhale. She was still alive at that time. So, I mean, in terms of our knowledge of her suffering, I'm not going to try and say we have definitive evidence of that. But I would suggest that considering all of the evidence in this case, there was more than sufficient evidence to survive a motion for required finding, and that the verdicts were consonant with justice. And so 33E consideration should be denied in this case, or should not be
All right,
granted.
thank you.
Thank you.